victims facing agonising delays, with some trials not listed for years. All the while, defendants bide their time. The guilty plea rate has decreased every year since the year 2000. And in the year to June, 11,000 cases were dropped after a charge because victims no longer supported or felt they could support the case. Behind the statistics are real people. Katie was repeatedly abused by her partner. She reported him to the police in 2017, but then had an unbearable 6-year wait for justice. During this time, she lost a job due to her mental health deteriorating. She became increasingly isolated, lived in fear, and lost faith in the court system. Mr. Speaker, this is not isolated, it's systemic. We're all proud of our justice system rooted in the Magna Carta, but we must never forget that it implores us not to deny or delay justice. When victims are left waiting for years, justice is effectively denied to them. And this is a betrayal of our legal heritage, and it's a betrayal of the victims themselves. Some will ask why we don't simply increase funding. This government has already invested heavily in the courts, nearly 150 million to make them fit for purpose, 92 million committed per year for criminal legal aid solicitors, and funding for a record number of sitting days in our Crown Courts, 5,000 more than those funded last year by the previous government. Today I can announce up to £34 million per year in additional funding for criminal legal aid advocates to recognise the vital support that they give to those navigating the system. I will also accept Sir Brian's recommendation to match fund a number of pupilages in the criminal area, to open a career at the criminal bar to more young people from across society. I will also negotiate sitting days with the senior judiciary through the usual Concord Act process, aiming to give an unprecedented 3-year certainty to the system. I'm clear that sitting days in the Crown Court and Magistrates' Courts must continue to rise, and my ambition is to continue breaking records by the end of this Parliament. But as Sir Brian has made clear, investment is not enough. The caseload is projected to reach 100,000 by 2028, and without fundamental change could keep rising, meaning justice will be denied to more victims and trust in the system will collapse. Mr. Speaker, to avoid that disaster, I will follow Sir Brian's bold blueprint for change. First, I will create new swift courts within the Crown Court with a judge alone deciding verdicts in triable either-way cases with a likely sentence of 3 years or less, as Sir Brian recommends. Sir Brian estimates that they will deliver justice at least 20% faster than jury trials. And whilst jury deliberations remain confidential, judges provide reasoning for their verdicts in open court. So this will hardwire transparency into our new approach. Sir Brian also proposes restricting defendants' right to elect for jury trials, a practice not found widely in other common law jurisdictions. And let's be honest, it's a peculiar way to run a public service. Our world-leading judges should hear the most serious cases, and I agree that they and the magistrates should decide where a case is heard. This will prevent defendants from gaming the system, choosing whichever court they think gives the best chance of success and drawing out the process, hoping victims give up. And I will limit appeals from the Magistrates' Court so that they are only allowed on points of law to prevent justice being delayed further. Alongside these changes, we will increase Magistrates' Court sentencing powers to 18 months, so they can take a greater proportion of lower-level offending and relieve pressure on the Crown Court. I would also take power to extend that to 2 years, should it become necessary to leave further pressure. And when it comes to exceptionally technical and lengthy fraud and financial trials, judges will be able to sit without a jury where appropriate. While these cases are small in number, they place undue pressures on jurors to sit for months, a significant interference with their personal and professional lives. These reforms are bold, Mr. Speaker, but they're necessary. I'm clear that jury trials will continue, to be the cornerstone of the system for the most serious offences, those likely to receive a sentence over 3 years and all indictable-only offences. Among others, this will include rape, murder, manslaughter, grievous bodily harm, robbery and arson with intent to kill. Mr. Speaker, I'd like to clear up some misconceptions that colleagues unfamiliar in this area might hold. In England and Wales, magistrates have long done the vast majority of criminal cases. That was true in the Victorian era, it's right through to Winston Churchill's time, and today magistrates hear about 90% of criminal cases. In fact, only 3% of trial cases in England and Wales will ever go before a jury, and almost 3/4 of all trials going to the Crown Court will continue to be heard by them under our changes. The party opposite talk about the Crown Court as if it were an ancient institution. I should remind them that it was established in 1971, the year before I was born, to replace a patchwork of part-time courts unable to cope with the rising caseload. Parliament acted because the country needed a more efficient system that could command public confidence. We now face an emergency in the courts, and we must act. As Lord Chancellor, my responsibility is to ground reform in the rule of law and the right to a fair trial. We will ensure cases are dealt with at the right level, proportionate to their severity, and deliver the swifter justice victims deserve. I'm also clear that we must future-proof our approach. Technology is changing almost every aspect of our lives, and the courts can be no exception. This means that we must modernise, Mr. Speaker. We have asked Sir Brian to write a second report focused on efficiency and how we can make much better use of technology to deliver the modern and effective courts the public rightly expect. Mr. Speaker, we'll also continue to support victims to make sure that they have the confidence to come forward and see justice through to its conclusion. I announced this week that I will provide multi-year funding for victim support services, including specialist emotional and practical support for victims of domestic violence and domestic abuse, and increase budgets to reflect rising costs. And this will give providers a certainty to plan for the next 3 years. And it amounts to a total investment, a record investment in victims of £550 million, more than £500 million. I want those victims to stay the course. Finally, we must also be honest that this is a problem that has taken years to build up. It will take years to fix. The changes I'm proposing will require legislation that will take time to implement. Our investment will also need time to have an effect. But we are pulling every possible lever to move in a positive direction, and my ambition for the backlog to start coming down by the end of this Parliament remains, and I commend this statement to the House.